Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court justice, with me, Jill Barton. On this episode, our AI hosts explain a skill you need to start honing even before the first day of law school: how to read and brief a case. They'll talk about an old case involving a bear walking down the street and spooking a horse. You can find a copy of the case on page 11 of the handbook for the new legal writer, or in lesson 5.1 of the Supreme Grammar course. So let's listen in.
Welcome to our deep dive. Today, we're tackling maybe the absolute first skill you need for law school.
That's right. How to read and, crucially, how to brief a legal case. It's foundational.
Totally. And we're pulling our insights from the handbook for the new legal writer by Jill Barton and Rachel Smith.
Yeah, and our goal really is to give you a clear roadmap for understanding these court opinions, sometimes just called cases.
Right. Cases.
Getting this right helps you succeed from day one, and honestly, it helps make you a better, more modern writer too. It's not just about class.
It's fundamental legal analysis, basically.
Exactly.
So let's talk about reading these things first, because they're not like reading anything else, are they?
Oh, definitely not. The handbook nails it. Court opinions can be, well, intricate. You've got complex legal issues, sometimes really archaic language.
Yes.
Unfamiliar terms, analyses that can seem, totally confounding at first.
So what's the approach? How do you even start?
The handbook stresses reading slowly, really slowly, and actively.
Actively. What does that mean in practice?
It means you're engaged, you're questioning. You might honestly need to read an opinion 2, maybe even 3 times.
Wow. Okay.
Yeah, to really get the nuances. Your goal isn't just to know what happened, but how and why the court decided what it did.
How and why? Makes sense.
So, practically, find a quiet place, no distractions. If your mind wanders, pause. Don't just skim past words you don't know, look them up, especially legal terms.
That sounds like solid advice. Setting yourself up for success.
It really is. That initial effort pays off.
Okay, so you've done your slow, active reading. You've wrestled with the text. What's the handbook say is next for really nailing it down?
That's where the case brief comes in. It's basically your personal summary, your breakdown of the opinion.
Like notes, but structured.
Exactly. And make sure you pull out and save the important stuff for later. And, lawyers keep doing this, maybe in shorthand, but the skill sticks.
Okay, so the handbook outlines 8 key parts for this brief.
That's right. 8 steps to deconstruct the case. It's like a template.
Let's walk through them. What's number 1?
First up is the case name and citation. Seems basic, but it's important. It tells you who the parties are, plaintiff versus defendant, or maybe appellant versus appellee if it's on appeal.
Appellant is the one appealing. Appellee defends the lower court's decision.
You got it. And the citation is like the address where to find the official opinion. So for our example, Bostock Ferrari Amusement Co. v. Brocksmith.
Okay.
That tells you Bostock Ferrari is the defendant appealing, and Brocksmith is the plaintiff defending the win below. The numbers and letters tell you the volume, reporter, page, court, and year.
Got it. Step 1, know the who and where. What's step 2?
Procedural history. This is the case's life story in the court system before this opinion.
How it got here.
Exactly. So for Bostock Ferrari, the plaintiff, Brocksmith, sued the bear owner for negligence. He won $750 at trial.
Okay.
The defendant, Bostock Ferrari, didn't like that, so they asked for a new trial, got denied, and then appealed. That's the journey.
All right. History covered. Number 3.
The issue. This is the core legal question, or maybe questions, the court is trying to answer in this specific opinion.
The heart of the matter.
Precisely. For the bear case, the issue was something like, is the owner of a wild animal, like this bear, liable for negligence if the injury wasn't caused by the animal being, vicious?
So not about an attack, but about the horse getting scared.
Right. That's the specific puzzle.
Okay. Issue identified. What's number 4?
The facts. But not just any facts, the legally significant ones, the details that actually influence the court's decision.
So cut the fluff.
Exactly. For Bostock Ferrari, key facts were: plaintiff got hurt driving his buggy when his horse saw the bear on the street and freaked out.
Right.
But 2T, the bear's owner was lawfully transporting it. And importantly, the bear was muzzled, chained, under control, and witnesses called it gentle, kind, and docile.
Those details matter. A gentle bear is different from a rampaging one.
Legally, yes. Very different.
Makes sense. Okay, number 5.
The rules? These are the legal principles or laws the court pulls in to make its decision.
The legal toolkit.
Kinda, yeah. In the bear case, the court looked at rules like One, if a wild animal attacks someone, the owner's negligence is generally presumed.
Okay, rule one.
And two, an owner has to use the care an ordinarily prudent person would in similar situations to avoid unnecessary injury. Like basic negligence standard, but applied here.
Got it. The relevant laws. What's number 6? This feels like the important one.
It is. Number 6 is reasoning. This is the court explaining how it applied those rules to those specific facts. The handbook calls these the anchors.
Anchors.
Yeah, because they anchor the conclusion. It's the court showing its work, why the decision makes legal sense.
So how did the court reason in the bear case?
Well, they said just seeing a wild animal doesn't automatically make the owner liable, especially if they have a right to transport it. Kind of like seeing a car for the first time might scare a horse.
Interesting comparison.
And crucially, the bear didn't attack. So that first rule about presumed negligence for attacks doesn't fit the facts here.
Okay.
They even compared it to another case, Scribner v. Kelly, involving an elephant scaring a horse. The court said the fright was from the unfamiliarity of the object, not because the elephant itself was being dangerous.
So the bear being gentle and controlled was key to the reasoning.
Absolutely key.
Yeah.
This part, the reasoning, is where you really dig into the court's logic.
All right, that leads us to number 7, the answer.
Yes, number 7, the holding. This is the court's direct answer to the issue we identified earlier.
The bottom line.
Pretty much. For Bostock Ferrari, the holding was, no, the defendant wasn't negligent. Why? Because they had the right to transport the bear lawfully. And given that the bear was gentle, controlled, and not inherently frightening in its manner, the owner did nothing wrong just by having it on the street.
Okay, clear answer. And the last piece, number 8.
Finally, the order or disposition. This is the court's instruction. What happens next?
The practical outcome?
Right. In this case, the court said, judgment reversed, meaning the lower court's decision for the plaintiff was overturned, and they instructed the lower court to grant the defendant's motion for a new trial.
So the bear owner gets another shot, essentially.
Basically, yes. Previous $750 reward is gone, and the process might start over or end differently based on this ruling.
Wow, okay. Those 8 parts really do seem to cover everything. Case name, procedural history, issue, facts, rules, reasoning, holding, disposition.
They do. And practicing with these, brief after brief, is what builds that core legal reading skill. It sharpens your analysis, builds confidence. It truly is a roadmap, like the handbook says.
So for everyone listening, as you start digging into these cases using this framework, what's the bigger picture here?
Well, it's about more than just summarizing. You're learning to think like a lawyer, but also think critically.
Critically how?
As you brief, ask yourself, was this fair? Does this outcome really serve justice? Remember, these opinions are written by people, smart people. They aren't infallible.
So briefing isn't just about accepting the court's word.
Not at all. It's about understanding it deeply enough that you can question it. You can engage with the law and not just learn it by rote. That's a crucial step in your journey.
So briefing every case you read and recording those 8 key parts is an important part of your law school journey. And it will take practice to figure out how to best approach your case briefs, because in the end, these briefs are just for you. They will form the basis of the notes you use for your law school exams. Thanks for listening. And remember, you can be a great legal writer.